My dear students, welcome back to our channel. In this video, I will be explaining the Bcom second semester subject Business Laws as prescribed by Osmania University and other universities of Telangana. We will go through the important questions and answers one by one. Let's begin with a quick revision. Unit 3 first important short question is: what is a trademark? A trademark is a special sign, word, logo, or symbol that helps people recognize a brand, company, or product. It shows that the product comes from a specific source and helps protect it from being copied by others. For example, the Nike tick mark is a famous trademark. Whenever we see it, we instantly think of Nike shoes or clothes. In India, trademarks are protected under the Trademarks Act, 1999. A registered trademark gives the owner legal rights to take action if someone copies or misuses it. Key points to remember: it builds brand identity. It prevents others from using the same or similar mark. It can be a name, word, logo, sound, shape, or color. Simple tip: trademark is equal to brand name's legal shield. Example, Amul is a trademark for dairy products. So, a trademark helps businesses grow and stay unique in the market. Next important short question is: 2. What is a patent? A patent is a special legal right given to a person or company for inventing something new and useful. It means no one else can make, use, or sell that invention without the inventor's permission. A patent protects the hard work and creativity of inventors. In India, patents are governed by the Patents Act, 1970. Key features: the invention must be new, useful, and not obvious. The patent is usually valid for 20 years. After getting a patent, the inventor can earn money by selling or licensing it. Example: if someone invents a new water purifier that saves more water, they can apply for a patent. Once approved, no one else can copy that design without permission. Easy tip to remember: patent is equal to protection for inventions. Like a lock on your idea. So, patents help encourage innovation and reward creative thinking. Next important short question is: 3. What is copyright? Copyright is a legal right that protects the original creative work of an author, artist, or creator. It means no one can copy, use, or sell that work without the creator's permission. In India, copyright is governed by the Copyright Act, 1957. It applies to books and poems, songs and music, paintings and photos, movies and software. Features: copyright is automatically given as soon as the work is created. It usually lasts for the lifetime of the creator plus 60 years. It gives the creator the right to earn money from their work. Example: if a student writes a story or makes a song, no one can copy or publish it without their permission. Easy tip to remember: copyright is equal to right to copy. Only the creator has the right to copy or allow others. This law encourages people to create more music, books, art, and software. Next important short question is: 4. What is copyright infringement? Copyright infringement means using someone else's creative work without permission, which is illegal. If you copy, share, sell, or perform someone's work without their approval, you are violating their copyright. Examples of infringement: downloading or sharing movies or songs without permission, copying a book and selling it as your own, Using someone's photo or art on your website or project without credit or license. Easy example. If Rahul copies a famous author's short story and submits it in a competition as his own, it is copyright infringement. Consequences: fine or legal punishment. Work can be removed from public platforms. Loss of reputation. Easy tip to remember. Copying without asking is equal to breaking the law. To stay safe, always take permission or give credit to the original creator before using their work. Next important short question is: 5. Define the intellectual property rights. Intellectual property rights, IPR, are legal rights given to people who create something original like ideas, inventions, brands, designs, music, or books. These rights protect their creativity and stop others from copying or using it without permission. Types of IPR. 1. Copyright for books, music, movies. 2. Patent for inventions, like a new machine. 3. Trademark for brand names or logos. 4. Design for product appearance. 5. Geographical indication, GI, for products from a specific place, like Darjeeling tea. Example. If Anjali invents a new type of mobile charger, she can get a patent so no one else can make or sell it without her permission. Easy tip to remember. Your ideas, your rights. IPR encourages innovation by making sure creators get credit, control, and money from their work. It's like giving a lock and key to protect your mind's creations. Next important short question is: 6. What are trade secrets? A trade secret is any secret business information that gives a company an advantage over its competitors. It could be a formula, process, design, or method that is not known to the public. The main point is it must be kept secret. Example. The recipe of Coca-Cola is a famous trade secret. No one knows the full formula except a few trusted people. If the secret gets out, other companies can copy it, so it's protected carefully. Important features. Not registered like patents. Protected by confidentiality, privacy, and contracts. If someone steals or leaks it, it is called trade secret theft. Easy tip to remember. If it's secret and valuable to a business, it's a trade secret. Companies often ask employees to sign an NDA, non-disclosure agreement, to keep trade secrets safe. Trade secrets are like the secret masala of a business, kept hidden but very valuable. Next important short question is: 7. Geographical indicator. A geographical indicator, GI, is a name or sign used on products that come from a specific place and have special qualities or reputation because of that location. It connects a product to its origin. Example. Darjeeling tea, only tea grown in Darjeeling, West Bengal, can be called Darjeeling tea. Pochampally saris, Mysore silk, and basmati rice are other GI examples. Why it's important? GI helps protect local culture and skills. It gives value to Indian traditional products. Only registered producers in that area can use the GI name. Easy tip to remember. GI is equal to genuine identity from a place. Just like a passport proves your identity, a GI proves the authenticity of a product. GI tags are registered under the Geographical Indications of Goods, Registration and Protection Act, 1999 in India. Next Unit 3. Long questions. First important long question is: explain the process of obtaining a trademark. Process of obtaining a trademark. A trademark is a special symbol, name, logo, design, word, or slogan used to identify a product or service. It helps the public recognize the brand and prevents others from copying it. For example, the Nike tick or the Amul logo are trademarks. Let's understand how to register a trademark in India step by step. Step 1. Trademark search. Before applying, check if the same or similar trademark already exists. Use the online portal www.ipindia.gov.in. This helps avoid rejection due to duplication. Step 2. Filing the application. If your mark is unique, you can apply using Form TMA. You need to provide the logo or word mark, owner's name and address, class of goods services like food, clothing, software, etc. Date of first use, if already in use. Application can be filed online or offline. Step 3. Payment of fees. Fees start from 4,500 rupees for individuals, startups and can be 9,000 rupees for companies. Step 4. Examination. A trademark examiner will check your application. If everything is okay, it goes to the next step. If there are objections, a hearing may be scheduled. Step 5. Publication in Trademark Journal. If the trademark passes examination, it is published in the Trademark Journal for 4 months. This allows the public to raise objections if they feel your trademark is similar to theirs. Step 6. Registration. If no objection is raised or objections are resolved, your trademark gets registered and you receive a trademark certificate. Now, you can use the registered trademark symbol. Example. Let's say you create a chocolate brand called Choco Fresh with a unique logo. You can register that name and logo so that no other chocolate company can use them. Tip to remember. Search, apply, pay, examine, publish, register. Use this as a memory line. Next important long question is to list out different types of patents. Different types of patents. A patent is a legal right given by the government to an inventor. It gives the inventor the right to stop others from making, using, or selling their invention without permission. There are 3 main types of patents, each for different kinds of inventions. Let's understand them with simple words and examples. 1. Utility patent, most common. What it protects: new and useful inventions like machines, tools, methods, or chemical formulas. Example, a new type of washing machine that saves water. Why important? It protects how the invention works. Duration, 20 years from the date of filing. Easy way to remember: if it does something new, it's a utility patent. 2. Design patent. What it protects: the appearance or look and design of a product, not how it works. Example, a unique bottle shape of a soft drink, like the Coca-Cola bottle. Why important? It protects the outer design, useful in branding and marketing. Duration, 10 years in India. Easy way to remember: if it looks special, it's a design patent. 3. Plant patent, not common in India. What it protects: a new variety of a plant created through breeding or genetic engineering. Example, a new type of disease-resistant mango tree. Why important? Helps farmers and researchers protect their unique plant inventions. Duration, 20 years in some countries, like the US. Note: India protects plants through a separate law called PPVFR Act, not by patent. Summary table. Type of patent: what it protects. Example, duration. Utility patent: function, process, machine, water-saving washing machine, 20 years. Design patent: appearance, shape, design fancy perfume bottle 10 years. Plant patent new plant varieties disease-free rose plant not in India. Tip to remember. Function utility. Fashion design. Flora plant. This makes it easy to remember the 3 types of patents. Next important long question is 3. Transfer of patent rights. A patent gives the inventor the right to stop others from using, making, or selling their invention. But if the inventor wants, they can transfer this right to someone else. This is called transfer of patent rights. There are 3 main ways to transfer patent rights. 1. Assignment of patent. Meaning, the inventor, owner, sells the complete rights of the patent to another person or company. Example, a scientist invents a water purifier and sells all rights to a company like Tata. After this, Tata becomes the full owner and can use or sell the invention. Note, it must be done in writing and registered with the patent office. Easy way to remember, full sale is equal to assignment. 2. License of patent. Meaning, the inventor allows another person or company to use the invention for a specific time without selling it. Example, a person invents a solar-powered fan and gives a license to Bajaj to manufacture and sell it. The inventor still owns the patent but earns money through royalty fees. Can be exclusive, only one company can use it, or non-exclusive, many can use it. Easy way to remember, use without ownership is equal to license. 3. Transmission by law. Meaning, if the patent owner dies, their patent rights are passed on to legal heirs. Example, if a patent holder passes away, the rights go to their children or nominee. Easy way to remember, passed on by law is equal to transmission. Summary table. Method ownership transfer example key point. Assignment full transfer selling patent to a company permanent sale. Licensing no ownership change giving permission to use invention owner earns royalty. Transmission legal transfer passing to heirs after death happens automatically. Final tip to remember. A is equal to assignment, all rights given. L is equal to license, limited rights. T is equal to transmission, through death legal means. This makes learning patent transfer simple and fun. Next important long question is 4. What are the rights of patentee? Rights of a patentee. A patentee is the person who owns a patent, the legal right over an invention. The government gives this right so that the inventor can protect and benefit from their creation. Once a person gets a patent, they enjoy several important rights for 20 years from the date of filing. Main rights of a patentee. 1. Right to make, use, and sell the invention. The patentee can make, use, sell, or import the invention in India. Example, if someone patents a smart air purifier, they can make and sell it exclusively. 2. Right to stop others, monopoly right. Others cannot use, copy, or sell the invention without permission. If anyone does, it's called infringement, and the patentee can take legal action. 3. Right to license the invention. The patentee can give license to others to use the invention and earn royalty fees. Example, a person patents a special mobile charger and licenses it to Samsung. 4. Right to assign the patent. The patentee can sell or transfer the patent to another person or company. After the sale, the new person becomes the patent owner. 5. Right to surrender the patent. If the patentee no longer wants the patent, they can surrender it by informing the patent office. 6. Right to sue for infringement. If someone uses the invention without permission, the patentee can file a case and claim damages, compensation. Example to remember. Imagine Ravi invents a solar cooker and gets a patent. He can sell it himself, write 1. Stop others from copying, write 2. Give it to a company for royalty, write 3. Sell full rights to a big firm, write 4. Give up the patent if he wants, write 5. Sue anyone who uses it without permission, write 6. Tip to remember. MLA make, license, assign, stop others, surrender, infringement action. This makes patent rights super easy to learn. Next important long question is 5. What is the rights of copyright owner? Rights of copyright owner. A copyright is a legal right given to the creator of an original work like a book, song, movie, painting, software, etc. It protects the expression of ideas, not the idea itself. When someone creates a work, they automatically become the copyright owner and get special rights under the Copyright Act, 1957, India. Main rights of a copyright owner. 1. Right to reproduce. The owner can copy the work in any form, print, digital, audio, or video. Example, an author can print and sell copies of their book. 2. Right to distribute. The owner can sell or give license to others for publishing or selling the work. 3. Right to perform publicly. The work can be shown publicly, like singing a song in a concert or screening a movie. Example, a music composer's song can be played in a live show with permission. 4. Right to translate and adapt. The owner can make translations, movies, or other adaptations from the original work. Example, a novel can be made into a film or translated into Hindi. 5. Right to broadcast. The work can be broadcasted on TV, radio, or YouTube. Example, a news channel needs permission to show a documentary. 6. Moral rights. The owner has the right to be credited as the creator and can stop any distortion of the work. Example, if someone edits a painting badly and shows it as the original, the artist can stop them. Simple example. Priya writes a poem and owns the copyright. She can publish it, sing it in public, sell rights to a magazine, translate it into Telugu, stop others from using it without permission, and get credit wherever it's used. Tip to remember. Use the shortcut RDPTBM. Reproduce, distribute, perform, translate, adapt, broadcast. Moral rights. This makes copyright rights clear and easy to learn. Next important long question is 6. What are the terms of copyright? Terms of copyright. Copyright is a legal protection given to creators for their original works like books, songs, films, paintings, software, etc. The term of copyright means how long this protection lasts. Terms of copyright in India. As per the Copyright Act, 1957, the duration of copyright varies depending on the type of work. 1. Literary, dramatic, musical, and artistic works. Copyright lasts for 60 years after the death of the author. Example, if a writer dies in 2000, the copyright on their book will expire in 2060. 2. Cinematograph films. Copyright lasts for 60 years from the year of publication, release year. Example, a movie released in 1995 will have copyright until 2055. 3. Sound recordings. Same as films, 60 years from the date of publication. Example, A song recorded in 2000 is protected till 2060. 4. Photographs. Protected for 60 years from the date it is first published. 5. Anonymous or pseudonymous works. If the real author's name is not revealed, then copyright lasts for 60 years from the date of publication. If the name is later revealed, it changes to 60 years from the author's death. 6. Posthumous work. If a work is published after the death of the author, then copyright lasts 60 years from the date of publication. Tip to remember. Lamp 60. Literary, artistic, music, photographs. Most are protected for 60 years. Example. Ravi writes a novel and dies in 2025. His novel will be protected until 2085, 60 years after death. So, the copyright system gives long-term protection to encourage creativity, while eventually allowing public use after the term ends.